Now, I just want to apologize again. We've been having some technical difficulties getting the audio to work. Thank you for your patience. And thank you for joining us for today's webinar, From Sexual Harassment to Wage Theft, Issue Spotting for Lawyers Working with Low-Wage Workers in the Age of Me Too. My name is Sarah Medeiros, and I'm the Communications and External Affairs Assistant here at the National Women's Law Center. A few technical notes before we begin. All attendee lines will be on mute during today's webinar. We'll be taking questions after our experts are finished with the main presentation, and we encourage you to submit questions throughout the webinar, which you have been doing. And thank you for telling us that you weren't able to hear anything. We really appreciate that because we would not have known otherwise, and we would have just continued to go. So you can submit a question, as many of you have already seen, by typing it using the GoToWebinar chat window visible in your dashboard, which can usually be found on the right side of your screen. This webinar will have live captioning throughout, which you should be able to see currently at the bottom of your screen underneath the presentation. And lastly, the webinar will be recorded and is being recorded right now. As an attendee, you'll receive links to the recording of the presentation as well as the slides within the next few days. At this time, I'd like to turn the floor over to Sarah David Heidemann, Workplace Justice Fellow here at the National Women's Law Center.
Good afternoon, everyone, and thank you for your patience. I want to welcome you all to the webinar and thank you for joining us. We at the National Women's Law Center are proud to partner with the National Employment Law Project on this cross-training. Low-wage workers are particularly vulnerable to discrimination and abuse stemming from a lack of power and control in their workplace. Understanding how to identify and screen for a wide range of potential claims allows us to be better advocates and more fully serve our clients. Next slide, please. The National Women's Law Center has been around for over 40 years. We work across 4 issue areas: education, reproductive rights and healthcare, income security, and of course, workplace justice. Next slide. As you can see from this slide, the National Women's Law Center Fund, LLC, houses and administers both our legal network for gender equity and our Time's Up Legal Defense Fund. We launched our Legal Network for Gender Equity in October 2017 to connect individuals experiencing sexual harassment or other forms of sex discrimination at work, at school, or in accessing healthcare with attorneys willing to take on those types of cases. And we know that many of you listening are some of our network attorneys, so we thank you for your help in ensuring the success of this program. The Time's Up Legal Defense Fund connects those who experience sexual misconduct, including assault, harassment, abuse, and related retaliation in the workplace or in trying to advance their careers with legal and public relations assistance. And in some situations, we will also help defray costs for legal and public relations support. Next slide, please. Naja, will you tell us about the National Employment Law Project?
Yes, can you everyone hear me?
Yes.
Great, okay. So hi, I'm Naja Farley, and I'm a senior staff attorney with the National Employment Law Project, and I wanted to provide a little background on National Employment Law Project known as NELP. NELP will be celebrating its 50th anniversary next year, and it is an organization that works on behalf of workers to improve working conditions, expand access to safe work, strengthen social insurance protections, and to support low-wage workers and the unemployed. And NELP is proud to work with National Women's Law Center on these issues because we look to collaborate with community partners on advocacy campaigns and also advocacy networks in order to assist low-wage workers and generally improve the environment for workers nationally.
So at this time, we are going to ask for a little audience participation. If you could please help us by answering the 5 multiple choice questions either in the bar on the right side of your screen or showing up as a quick poll in the center of your screen. All right, and we are going to move on to the second question. And we're moving on to the third question. And fourth question, thank you all for helping us with this information. And the fifth and final question. Thank you all for your participation. I'm going to turn things over now to Sunu Chandy, the Legal Director of the National Women's Law Center.
Hi, everyone. Thank you to Sarah and Sarah here at the center for grace under pressure with that audio mishap. And thank you all for your patience staying on the line. I am delighted to be partnering with NELP on this cross training. I imagine many of you on the phone already know a lot about sexual harassment, but maybe not about what NELP will be presenting or vice versa. So thank you for your patience, and I think this will be very valuable for us to cross-train in this way. If these are areas you already know about, please let us know if you have any feedback about other things that we should cover in our basic sex harassment training. So the first slide here is just going through how sex harassment is an expression of power, and it plays out in sort of unique ways when there are other kinds of exploitation at issue. And in low-wage work, they're often overrepresented by women and women of color and immigrants. And there are other dynamics at play, such as not having a fair or predictable schedule, maybe not having health insurance, not having paid time off. And all of these things sort of exacerbate sex harassment, which does happen across industries and sectors. And we also want to mention women who are working in male-dominated industries. They often face particular instances of sex harassment too. So we're now going to go into some of the legal training and where these protections come from. And most of the time will be spent today on the federal protections that exist. And on the next slide, it goes through Title VII of the Civil Rights Act is where these protections come from. So Title VII prohibits discrimination on the basis of race, color, religion, national origin, and sex. And it is through the case law that it developed that sex include sexual harassment. And this is going through how the cases advanced in that way, leading up to Meritor Savings Bank in 1986. Next slide. Now, this case law developed to help us understand what the legal test is for sex harassment. It can be physical, it can be verbal, and it could be a combination of those. And it doesn't necessarily need to be sexualized. It can just be comments about one's sex or gender as well. Next slide. In terms of the federal protections, people who are unfamiliar with this area of law are often surprised that the federal law only covers employers that have 15 or more employees. So unless there are city or state protections, there could be, millions of people who have no protections at all in the workplace against sex harassment or any kind of harassment or discrimination if they work for a smaller company. And also independent contractors, unpaid interns, these folks are also not included as employees. Another thing to know in the federal standard is that you have to file typically within 300 days of the last incident. In some places, it's only 180 days if there's no city or state or local protections. Now, sexual harassment legally, there's two forms that we typically think about. One is quid pro quo. If someone says, sleep with me, have sex with me to get a job or to get a promotion, or if you don't sleep with me, I'll fire you. Those are sort of what you may think of as classic sex harassment. And it's called quid pro quo. The other kind is hostile work environment. And that occurs if the conduct is severe or pervasive. And that is the legal test on the federal level. There's a lot I could say about that. That could definitely be its own webinar, but suffice it to say, it's extraordinarily discretionary. If there's a sexual assault or a rape, that would be considered severe by most courts. If there are a few sexual comments or jokes, that would typically not be considered severe. And unless it went on for a long time, it probably would not be considered pervasive. So the legal test on the federal level is quite discretionary. And that also brings up the issue of the various judges who are being nominated now to have that kind of discretion. And when you see how they've interpreted this, it's quite alarming. Even groping, one or two groping, has been found by some courts to not meet the test for severe, for example. So this is something to be aware of. Fortunately, some localities have created standards that are more reasonable, and sort of in New York City, they've done that. It's anything that's not a minor incident or issue can be sexual harassment if it's sexualized conduct in the workplace. So that's also something to be really aware of. Next slide, please. Now, in terms of the process of bringing a claim or a case forward, if you want to go to federal court with an employment discrimination case, you first have to go through a federal agency and a charge filing process. And what you write in that charge is really important. So it's important that lawyers are involved in that process, but you don't have to have a lawyer to go to EEOC. And if you're up against your time frame of 180 days or 300 days, I would always say get in there and have, do not lose your case because you don't have a lawyer. But whatever is written in that charge, you then have to live with for the rest of the case. Again, the EEOC process has many steps and procedures. I worked there for many years, but for today's purposes, I think the point is it could settle, it could mediate, it could be investigated, or the lawyer can just file the charge and ask for a right to sue letter. It depends on what the state of the backlog is at EEOC, if they will give it to you right away. Sometimes they have to say, we can't get to it in the next 6 months, and so we can give it to you. So the key thing here is if you get that right to sue letter, you have to file within 90 days. Now, the other thing to know is what you're able to recover in these cases, and there's back pay or front pay, and there's also been some legislative action on how these settlements are taxed, and that's something to be aware of. I think finally the tide is turning, and it seems unfair that you go through all these hoops, you get a settlement, which, by the way, look at I will read out the compensatory and punitive damages. The maximum available are between $50,000 and $300,000, depending on the size of the employer, no matter what happened to you. So you might get your front pay or back pay, but your compensatory and punitive damages, even if you were assaulted or severely harassed, if you're working for a smaller company, the maximum would be $50,000 under federal law. Now, again, there could be state or local damages in addition to that. And the next slide talks about some of these changes that can happen on the state and local level to be more inclusive. There could be explicit protections for LGBTQ individuals. There could be more reasonable standards. You could have longer to file. That's something that's under consideration now as well on the legislative side. Perhaps it should be 3 years, as with other kinds of claims. And there's some states that have requirements of anti-harassment training, either for public employees or even for all employees. Next slide, please. I also want to make sure to mention retaliation. It's if someone brings a charge formally or even brings a complaint to the employer or participates in someone else's complaint, any of those are considered protected activities. And if you engage in those, then the employer engages in adverse action, which doesn't need to be a firing. It can be sort of icing you out from projects or not giving you what you need to do your job well. That is a standard that's slightly looser. And so if you're in your particular workplace, if what's valuable is something that's being taken away from you, that could give you a retaliation claim. Now, things that you have to show, of course, are notice to the employer that you took action in some way, and then an adverse action. Important point about retaliation is the underlying conduct doesn't need to be illegal, harassment or discrimination. If you think something violated your civil rights and you have sort of came forward in good faith and brought a complaint and then you're fired, you're absolutely protected against the retaliation, even if the conduct appears to be not illegal. Next slide, please. Now, whether or not an employer is liable is dependent on a few things, but a key thing is if the harassment is by a supervisor, with someone who can hire and fire you. If that person engages in harassment, the employer is vicariously liable. Now, the exception to that is if they put policies and procedures in place to let you know what to do, and that as the employee, you unreasonably didn't use those policies and procedures. That can be an affirmative defense. So that's a very important point. If there is a policy and procedure, it's important to use it so you're not dinged with this as defense, but also if the harassment is by a colleague or a third party or a customer, it's also important to use it because that's how you show notice. If the employer has noticed that this kind of thing is happening, they should take proper remedial action. Okay, next slide. Okay, I think we can go past this one. That just talks a little bit more about coworker harassment. And I've put the case law together on Price Waterhouse and Oncology just to show how sex discrimination has been appropriately expanded by the courts to be more inclusive. But in the interest of time, we can go to the next slide. Same here, just sometimes women of color or women with disabilities or other individuals face discrimination on multiple fronts. And there was a time where courts were trying to use defenses of, well, we don't treat all women horribly, or we don't treat all Black people horribly. And the courts have recognized that there is intersectional discrimination, and that is a real thing. All right, next slide, please. So for sexual harassment intakes, because the cases are so fact intensive, it's really important to get all of the details so you know if you can meet that severe or pervasive test. I think that's my key takeaway to individuals who are not aware of this area of law. I mean, when I worked with EEOC investigators, sometimes it'd be just a few examples of many, many, many things that happened. And just based on those examples, I thought, well, maybe this doesn't meet the test. But so that's an example of if you're writing an EEOC charge, it's so important to say, this happened for a year, this happened for 6 months, and here are several of the examples, because whoever's looking at that is making an assessment about if what's presented meets that test of severe or pervasive. So you can't often list everything, but it's important to say many instances, including, or give some indication of frequency. Because of the time frames that you have to file, obviously you need to ask how long ago the events took place. There is a legal theory called continuing violation. So if something happened within the last 300 days and went on for 5 years before then, the theory is as long as you file within 300 days of the last instance, you can bring in all of that conduct. There could be a whole training on if that's just for the person or other people who experienced harassment in that time frame. That's also something that we can think about and talk about further after this if people have specific questions. So when the conduct took place, it's so important to ask the details about trying to figure out if it meets that legal test. Did they follow the procedures for the reasons we talked about? We don't want to have an affirmative defense come in later, and whether there's retaliation. So did anything change after the person made a complaint, if she or he made a complaint? And next slide. Now we wanted to just mention that these are real lives and stories of trusting people who contact us, as you all know, as lawyers. And we are looking at how we can be more aware of the emotional impact and have some people talk about a trauma-informed intake process. And so we've gathered a few tips from various sources, and this is something that is very much a work in progress, and we welcome input and feedback from you all about how we can collectively make sure to engage in these difficult interviews about sexual assault and sexual harassment in ways that re-traumatize the person as little as possible while getting the information we need. That's so important. And we are also looking at how we can have referral lists. I mean, we're all lawyers, so we need to think about disclaimers and other issues of liability, but often people who come forward, it may even be too late to bring a charge because too much time has passed with the statute of limitations, but individuals still are empowered by bringing their stories. I mean, earlier today I was presenting at with a media outlet about how much people telling their stories through the press and through finding other survivors is empowering, even if there's no legal claim. Now, through the network, you can have a lawyer standing by if you face threats of defamation or other kinds of retaliation for coming forward. So we want to work with you all to think about how best to really get the legal information we need from individuals, but also be very mindful and considerate that these are horrendous circumstances that individuals have faced and are really taking a risk to come forward and talk about them with anyone, or much less a lawyer. So thank you for all of your work in this area. And the next slide is some of the relevant links to join our legal network so that we can send you individuals who may have need for your assistance through free consultations. There's also the Time's Up Legal Defense Fund, where we fund cases through different stages that meet certain criteria, and you can look on our website for that. We also have a very soon deadline of June 29 for our outreach grants, so take a look at that soon if that's something that makes sense, or if you know of workers' rights or other organizations that should apply for that. We also have the Me Too What's Next, which is focusing on policy. So all of the things that I mentioned in the current law just sort of invite advocacy and action on the policy front, right? Lowering the threshold for number of employees, increasing the amount of time you have to bring a claim, having a more reasonable standard for quote unquote what counts as sexual harassment. These are all just areas that are ripe for improvements. And we also have a general fact sheet, a FAQ. And I think the next slide is our last slide, and we will stand by for questions after the note presentation. Thank you all for taking part in this. Thank you for your patience and for being part of what I think is really a movement of lawyers to help fight sex discrimination. Thank you.
Great, thank you, Sunu. Now I'm going to invite Naja Farley from the National Employment Law Project to take us through the next set of slides. And a number of you have asked about whether we will be sending out the slides after the presentation, and the answer is yes. So keep an eye on your email inbox for the PowerPoint presentation after today.
Hi, my name is Naja Farley, and I am going to be discussing sort of a wage and hour overview, and then afterwards, my colleague Laura Weezar is going to be discussing immigration-based retaliation. And so I wanted to just start out and say that we thought it would be helpful to put together these topics because so often women of color and other people in low-wage industries suffer from both sexual harassment, sexual discrimination, and also wage and hour issues and workplace safety issues. So we thought that for some of the attorneys in the legal network for gender equity, if they didn't necessarily have familiarity with all of these issues, this might be a good way to have some baseline information when they bring people in to start an intake. And another thing that has come up, at least in my personal experience, is that when you're doing an intake and talking about the workplace, other issues come up that weren't not necessarily on your radar as the attorney in the first place. And so I thought we thought it would be good to come together to talk about these issues together. Next slide, please. Okay, so this is just an outline of the issues that I'll be talking about. Next slide, please. So one of the issues that we at NELP are very concerned about is the issue of wage theft. And wage theft is the unlawful practice of not paying workers for all of their work. And usually it is a violation of both the Federal Labor Standards Act, but the workers can also look to state or local law to remedy issues with wage theft as well, because now there are a number of states and localities that regulate and have enforcement agencies that regulate wage and hour. And the magnitude of the problem is very large. There are a number of studies that show that these types of violations have resulted in losses of up to $8 billion annually for workers. And that in light of the issues with Me Too, we found that also younger workers, women, people of color, and immigrant workers are more likely to suffer from wage theft violations as well. Next slide, please. Okay, so starting with minimum wage, the minimum wage is governed by the Fair Labor Standards Act, which is the federal law that governs wages, but there are also higher wages available, or certain states have higher minimum wage than the federal law. So it would be good also to look into the minimum wage in your particular state. And another issue that NELP works on frequently is the Fight for 15 and the movement to raise wages throughout the country, and a number of states are currently involved in those campaigns. So I would encourage everyone to keep an eye out for them as well, those campaigns. There are a number of issues that come up with intake on minimum wage, and I think these are some of the questions that you may ask someone if they are talking about this issue, looking at what is your rate of pay, how often are you paid, are you paid for all of your hours worked? Also, I would ask workers if they clock themselves in or out, if they are able to keep adequate track of like how often they work or what their hours are. Those are the types of things that could help you figure out if there is an issue with workers being paid the minimum wage in their particular job. Next slide, please. Okay. So I also wanted to talk a little bit about overtime issues. There are a number of different issues that come up if a worker comes in and they're in the context of the discussion talks about, whether or not they're receiving overtime. There are a number of different tests for this, but under the who is eligible for overtime is determined by looking at their salary and also their duties. And the typical job duties that are not eligible for overtime are the executive, professional, and administrative duties. And you have to look to case law to determine whether someone falls into those categories. There are also like larger categories of workers that are not eligible for overtime as well, such as farm workers, seasonal workers that are not eligible. So in this context, I would say that for someone new to this area, I wouldn't try to suss out whether or not a person is exempt or non-exempt, but instead talk to them about like if they think they're having issues with potential overtime issues or they're not being paid appropriately, to start to empower the workers or encourage them to keep notes about their workplace in a safe place where their boss or supervisor wouldn't see them, about like what hours they're working, what their rates are, and just like keep an idea of like what's going on, so that if there is a chance so that when you all are coming up with like a plan for a referral or looking into where else the worker might be able to go, they'll have like a good idea or a good let's say information about what is going on in the workplace to take a next step on these issues. And as I have at the bottom of these slides, and then also later on, if anybody needs to contact, find out more about possible referrals or more information about these issues, or has suggestions for things that we did not cover, definitely get in touch with us. Okay, we can move on to the next slide. So another issue that comes up that is a little not exactly related, but it's also sometimes mentioned along with overtime, is the issue of independent contractor misclassification. And I guess the reason why they're somewhat discussed together is that like if a worker is misclassified as an independent contractor, then they may not receive the appropriate overtime for their work and things of that nature. So that's why it goes under the rubric of like wage theft in this context. And obviously the issue of like whether or not someone is an employee or independent contractor is also very relevant for determining whether or not they will be able to move forward with a claim for sexual harassment as well. As Sunu Chandy talked about, independent contractors are not able to move forward with claims under that if they are classified as independent contractors. So there are, starting from looking at a worker that's coming in, like certain occupations are known for having misclassification issues, certain industries such as home care, trucking, construction, and some types of work that fall under the rubric of the gig economy. Those jobs are known for having issues with misclassification. So that is one thing to look to. And also, if after talking with a worker about this, you still have some questions, you can look at, who is actually responsible for supervising the work, who's in charge at the work site, who pays the worker, who's in charge of like the management of the worker. Those types of things might give you an idea of like how to look into this issue, and also give you an idea of like where to refer someone who's having issues with misclassification. And just because this issue is so complicated, it would definitely be important to refer someone if you do come across this issue, but just get the baseline information so that you can help them move forward. Next slide, please. We also wanted to talk a little bit about health and safety resources. If an employee suffers from discrimination after they file a complaint concerning occupational safety and health, then they have resources under OSHA's Section 11C to make a complaint. But the issue with this is that the complaint has to occur within 30 days of the violation. But in the event that they do make the complaint in a timely fashion, it will trigger an investigation by the Secretary of Labor. And the possible relief may include rehiring or reinstating the employee to his former position with back pay. And also, I guess, in the event of a worker complaining about safety or health hazards in their workplace, it would be good to also remind or assist them with maybe looking into filing a safety and health complaint itself in order to correct the hazard on the work site and, hopefully make the workplace safer. So, and also in terms of those types of complaints, like I said earlier, you can also, if there's retaliation based on those complaints, they have the resources available under Section 11C, and also in some states they may file workers' compensation complaints alleging retaliation or unlawful discrimination if there are issues that come out of filing such a complaint. Next slide, please. So I think that we're reached at the end of the presentation. These are more, I call them red flags, but I think they're more like just issues to keep in mind or issues that if they come up would warrant further investigation and possible referral to an attorney that specializes in these issues. So if a worker, let's say, does not know the name of the employer, if they're unsure of their pay rate, has issues with being paid in a timely fashion, they have to, go around to try and get paid, unsure of their pay rate. Those are like baseline issues. But also like in terms of retaliation, if like, let's say like a worker, has issues that come up with being paid after they complain about issues in the workplace, or has issues with their hours or scheduling after they complain about issues in the workplace, those might also be things that may be fruitful in terms of looking at a retaliation claim. And I think I'm at about time, so I'm going to turn it over to Laura for her presentation.
Great. Thanks so much, Naja. If we could just get the next slide, please. And the next one, please. Great. So I'll start here. And again, my name is Laura Huizar. I'm a staff attorney with NELP in our DC office. And my focus here at NELP is largely minimum wage issues and the enforcement of basic labor standards. So wage theft, of course, is part of that. I thought that I would focus today on immigration-based retaliation, since this is an issue that has always been challenging for advocates, but has become even more pressing in this environment where we're seeing a lot more anti-immigrant sentiment and discrimination. So I'll talk a little bit about ways in which the Federal Fair Labor Standards Act offers protections for immigration-based retaliation, and then I will talk a little bit about ways or basic tools that attorneys can use to protect undocumented workers in litigation, so both in discovery and at trial. And so on the issue of immigration-based retaliation, I think for anyone who has worked with low-wage workers, it's a pressing problem and one that's been challenging for years and years. It's always been a problem. But NELP has been trying to reach out to our worker center networks and allies to really understand how the dynamics with employers have been changing for immigrant workers in the last couple of years, or since November 2016, really. One of the things we've heard is that workers are much more hesitant in this environment to come forward and to report employer violations. And it is because in many cases they are afraid of retaliation. And there's also a sense that employers are feeling much more emboldened right now to retaliate and to use workers' immigration status against them. So workers very legitimately have a fear of ICE involvement and even deportation as a consequence for coming forward. One statistic or one data point that I would highlight is, the fact that the LA Times reported earlier this year that complaints of retaliation to the California Labor Commissioner's Office increased to 94 in 2017 from 20 complaints in 2016 and from only 7 complaints in 2015. So at least in that state, there is some evidence that workers are coming forward to report more cases of retaliation. If we could get to the next slide, please. So when it comes to the Fair Labor Standards Act, as some of you might know, and I think it has been mentioned, there is protection under Section 215 A3 for workers who are retaliated against. And the section, as you can see in the basic excerpt here, prohibits discharging or discriminating against employees because those employees have come forward to file a complaint or have testified or are about to testify in a proceeding involving the wage and hour protections under the FLSA. If we could get to the next slide, please. And unfortunately, that language is, fortunately, I guess, and unfortunately, the language is pretty broad. It doesn't speak specifically to what constitutes retaliation or unlawful discrimination or discharge. But for those of us who work with low-wage workers or undocumented workers, it's important to keep in mind that courts have been recognizing the different ways in which employers retaliate against immigrant workers, and a lot of different forms of immigration-based retaliation have been found to violate the Fair Labor Standards Act. So I'll go over just a few kind of categories or areas where courts have been concluding this. So first, I would say a number of courts have found that reporting undocumented workers to government agencies like ICE can constitute retaliation under the FLSA. And I don't want to go into all of the detail for the cases that we cite here. I mainly wanted to provide them so that folks can look back to them as examples and try to find similar cases in your jurisdiction. But basically, when an employer clearly called ICE or INS in the past, and that may have resulted in the arrest or detention of a worker, there may be some good case law out there to support a retaliation claim. Next slide, please. There we go, thanks. Courts have also found that when employers threaten to report a worker to immigration authorities, that conduct too may support a retaliation claim under the FLSA. So for example, I included here a cite to a 2015 case in Florida where the court partially denied the employer's summary judgment motion in a case where the employer had threatened to call ICE and had also asked the worker to fill out a I-9 form. And that was the first time that the employer had asked this. And the court found that those things together were sufficiently severe, in the court's own words, to show that the plaintiff had shown enough evidence of a constructive discharge. And there's another 2016 case cited here where an employer had threatened to report a worker and his son to immigration authorities, and the court found that that alone was enough for the worker plaintiff to meet the initial prima facie burden of establishing retaliation under the FLSA. Next slide, please. Courts have also found that when employers ask about a worker's immigration status or make inquiries related to a worker's immigration status, that conduct can also constitute unlawful retaliation under the FLSA. So for example, the case cited here from 2006 essentially barred the employer from asking about employees' immigration status, and this was a Title VII case. And so the court found that just asking a worker to fill out an I-9 form when the employer had never done that before could indicate unlawful retaliation. And in the other 2015 case cited, a Florida court again partially denied summary judgment on the employer's retaliation claim, and part of that analysis focused on the fact that the employer asked for a new I-9 form from the worker. Next slide, please. And finally, I wanted to point out that courts have also found that third parties, so not just employers, can be held liable for immigration-related retaliation under the FLSA. So a 2009 case cited here shows a court denying a local county's motion to dismiss a retaliation claim where the county sheriff's office basically had allegedly coordinated with the employer to arrest plaintiffs who had asked to be paid what they were owed and who basically intimidated the workers in coordination with the employer. And then there's a 2017 case here from the Ninth Circuit where the Ninth Circuit denied a lawyer's motion to dismiss a retaliation claim where the attorney in the case, the attorney representing the employer, had allegedly worked with ICE to try to coordinate the detention of the plaintiff worker at a scheduled deposition. So when faced with potentially attorneys on the other side who may be engaging in this type of conduct, this could be a good case to bring to their attention. Next slide, please. Great. So I'll talk a little bit more about the ways in which litigators can protect undocumented workers once a case has started. And I think a very basic thing to keep in mind, especially for those who have not practiced immigration law or have not dealt with these immigration-specific issues much in the past, I think the key thing is to remember that you should try to prevent the employer, or whoever the defendant is, from getting to your client's alienage information. So oftentimes, defendants will start to ask just, what country a client is from, or make assertions about the fact that they're foreign born. And it's really crucial to keep any kind of information out that relates to alienage, because that information could be used later on in a deportation proceeding to try and deport that person. So anything pertaining to alienage should be kept out. Attorneys have found some success in seeking protective orders when it comes to discovery. So courts, especially I think in the wage and hour context, have recognized that asking about immigration status in wage and hour cases is often and usually, I think, irrelevant. It could have what courts have called an interim effect on workers, and so essentially a chilling effect on workers' ability to come forward. And I think courts have recognized that the risk of the injury to the plaintiff is generally far outweighed by the probative value of the information that defendants are seeking. And I think it's also important to remember to push back against efforts by defendants or employers to get tax documents from your client, because oftentimes those tax documents can include immigration-related information like social security numbers or ITIN numbers. And fortunately, a number of courts have allowed for protective orders when it comes to tax information. They've recognized that it can be a backdoor attempt to get immigration status information. And even though some courts have acknowledged that tax documents may be relevant to a plaintiff's credibility, they've also recognized that that information could be highly prejudicial to a worker, and it would have a serious chilling effect on workers' ability to come forward. So protective orders are really important to think about and to plan for. It's also important to remember that even in civil cases, it could be useful to assert the Fifth Amendment in potentially depositions or essentially situations where a protective order may not have already blocked sensitive information in the case. And it's always a good practice to make sure that your client or worker is using their real name in any complaint or paperwork or proceedings, since workers in some cases use aliases or other names in some of their documents. Next slide, please. And when it comes to trial, I think a lot of that same information applies. Instead of seeking a protective order, it's important to remember that it could be useful to seek or to file a motion in limine to basically bar the introduction of any immigration status or alienage evidence at trial. And courts have recognized a lot of the same reasons that are used for protective orders in granting those motions in limine. So that's important to keep in mind. And again, if a motion in limine doesn't protect a worker fully, attorneys should also consider using the Fifth Amendment at trial if necessary. Next slide, please. So I'll just very quickly go through a few things that attorneys can also do before litigation, essentially, or throughout, that can also be helpful. The first thing I would mention is that it can be really useful for workers, especially those who don't speak English, to have a palm card or some kind of card or information that they can use if they come across immigration agents or someone questions them about their status or anything else. And the card, like this sample, can basically say, I have the right to remain silent, and you can direct any questions to my attorney, and I'll refuse to sign any paperwork until I talk to my attorney. And this is a sample from the National Immigration Law Center. You can download it and make some copies for your clients if that's useful. Next slide, please. And then just a few other things that could be helpful are, number two, you can give your client a letter that they can show to immigration authorities if they come across them, which can basically say that those authorities should refer all questions to you and not question your client without you being present. You can advise your clients also to not use incorrect Social Security numbers with agencies or in any of their paperwork or future filings. You can ask agencies also, in some cases, to let your clients testify or attend hearings or meetings by phone or video conference. And this is because in some places we've seen that ICE has been showing up at courthouses or departments of labor. And so if you think that that is a serious threat, it's something you could do in advance and try to arrange that for your client. And finally, if an employer does threaten to retaliate, you can try to step in and through a letter or some other form, you can try to inform the employer that that conduct may be illegal and provide, some of the information we've talked about today. Next slide, please. And so finally, I just wanted to point to a couple of resources that might be useful as you're dealing with these issues. We have a fact sheet from NELP on how to protect injured immigrant workers specifically when they face retaliation. We have a handbook, essentially, or a sort of fact sheet on what to do if immigration comes to the workplace. And so workers may be able to find that useful. It's in 5 languages. There are the palm cards that I provided a sample for from NILC. There's also, there's some federal resources here, a copy of a memorandum of understanding that has been in place between DHS and labor agencies that could come in useful where ICE involvement essentially undermines existing labor investigations, and we're happy to talk more about that or answer questions as cases come up. But I think I've gone over my time potentially, so I'll stop there, and I'm happy to answer questions afterwards. Thank you.
Thanks very much, Laura and Naja. Again, this is Sarah from the National Women's Law Center, and we are now going to move into the question and answer section of the webinar. So if you have questions, if you could please send them to us, chat them to us, and our administrator will make sure that we see the question. We already have several questions, so as we're waiting for additional questions to come in, I will start with the first question. So the first question is about any resources for emotional distress that may be available for in cases of sex harassment.
Yeah, so this is Sunu again. I think what we've been looking at is there's a lot of work done by advocates in the DV community, the domestic violence area of work. And so if you have a local organization or agency, I would suggest calling them and seeing if they have either steps for, what to keep in mind, or even a list of referrals or resources that are local. We are looking at putting together a more national one, but that is going to take some efforts because we want to make sure that we try to call them all and see if someone's there to respond. And we may also put together something that just has different resources for individuals who are facing deep emotional distress, so on the national level. I also wanted to just chime in about the immigration-related retaliation because there are civil rights protections under the employment discrimination statutes there too. If an employer wants to retaliate against someone filing a charge with the EEOC or bringing a complaint internally or so on by engaging on immigration-related practices, by threatening someone or calling ICE or so on, the EEOC has been successful in obtaining protective orders. I think I left there 4 years ago, and at that point, we had been successful in getting those orders in every case because the timing was so obvious and the retaliation was so clear that the employers knew this before, but only made it a problem after someone spoke up about civil rights protections. So I just wanted to say there are comparable claims in that area.
Thanks so much, Sunu. So our next question says, I want to file a sex discrimination claim against an employment agency based on retaliation, terminating the employee for complaining about sexual harassment. Does the employment agency have to have 15 or more employees? That's another question for Sunu.
Okay, so this sort of implicates a couple of theories that are available: joint employer and integrated employer, and some courts have sort of confused these. But if it's really two separate entities and there's a staffing agency and a legitimately separate employer, then the staffing agency would have to have 15 or more to be liable on its own. But if it's some form of an integrated operation, then you could count all of the employees together.
So the next question is for my NELP colleagues, and the question says, I understand that if tipped employees do not get tips sufficient to add up to the minimum wage, the employer is obligated to make up the difference. But I've had a lot of trouble finding out what period that is supposed to be over, i.e., is it if you don't make the equivalent of minimum wage over a particular shift or over a particular pay period or something else? So Naja or Laura, I'm going to hand that off to you.
This is Laura from NELP, and I'm happy to answer that. And Naja, if you have any additions, that would be great too. I think my understanding is that under the FLSA, an employer has to comply with the tip credit requirements on a work week basis. And I believe under the FLSA, a work week is a period of 7 consecutive 24-hour periods. So essentially a week, but I don't believe that it has to start, on a Monday and end on the Sunday. I think it just, the employer can determine what the work week will be. So I think that applies for federal compliance, but there may be different definitions of a work week or different requirements, I think, at the state or local level. So I would look at your jurisdiction specifically too.
Yeah, I agree with that. I was thinking that you keep in mind that I think with minimum wage, especially, like, you have to look at the time period that's required that constitutes the week for them when doing the damages calculations, or under the law, I should say. I shouldn't say for them, but yeah.
Okay, great. So the next question is also for my NELP colleagues. It asks, what is the timeline for OSHA 11C investigation? How long from discrimination complaint to conclusion of investigation to reinstatement or back pay?
Naja, I don't know if you have experience. Oh yeah, go ahead. Mm-hmm.
Well, I don't have I have an idea from our NELP colleague, Debbie Berkowitz, who specializes in health and safety, and she said that that they can take up to 2 to 3 years from beginning to end. But we could definitely put you in touch with her if you had like more specific questions about the length of time.
And Naja, I would also add there's a link in the webinar slides that I used at the very end to a product that Debbie and I published together that goes over ways to address retaliation when there are workplace injuries, and it discusses some of those 11C complaint issues, and that might be helpful as well.
Great, thanks so much. And I'm going to turn it over, I think, again to Laura for a question. What results have you seen when pleading the fifth during discovery and at trial? And perhaps others can weigh in on this as well.
So I would say from my personal experience, I think I've only seen it used or had to use it in depositions a handful of times, and it has essentially worked to keep the work I'm asserting or from answering a question, and it was not challenged in my experience by opposing counsel. I think there's always, a fear, a recognition that opposing counsel may challenge the use of the Fifth Amendment, but I believe it's been used in other cases, depositions as well. I've personally never used it in a trial situation. I don't know if Naja or others, if you have thoughts on pleading the fifth in some of these cases.
No, I don't have any experience with that.
Yeah,
Okay.
it's come up in
I think we could also
depositions.
point you to some case law. Oh, oh, sorry. Go ahead, Sarah.
Sure. Just to say that in civil rights context, it's also come up in depositions. But we can also respond to the question askers directly as well with some additional case law if that's helpful. So the next question is for Sunu Chandy. What is the current state of transgender discrimination as sex discrimination under Title VII?
Yeah, so I'm looking back at slide 16 when you get the slides with some of the most recent case law. We recently did an amicus brief, I think, in the Missouri Supreme Court. They were looking at this issue, and there is a growing consensus in the circuit courts that sex includes both sexual orientation and gender identity. And we've cited the Hively case and Zarda and the EOC versus RG. I think the big difference right now is we've had several years now where the federal government was weighing in this way as well, and now is not. And so federal agencies are taking a contrary view. But I think these circuit opinions are quite good because they talk about how these lines really are not real, and that the discrimination really crosses these boundaries. And for many, many reasons, sex includes sexual orientation and gender identity, and that's the appropriate reading of the law. And as we've seen, sexual harassment isn't in the statute either, right? Pregnancy isn't in the statute either. The same-sex harassment isn't in the statute. This is how the case law has developed to include what sex discrimination means. And so this is the latest piece of that.
Great, thank you. The next question. We have been approached by an undocumented worker who is being harassed by another worker in the field. Is there anything we can do for her? Are there protections available to her?
I mean, I guess the first question is what kind of harassment? And that is a very broad question, but the key things to think about are who are the people doing the harassing, and is there some basis to tie it to any of the federal categories that we talked about? Is the harassment itself include any language that's tied to a particular country or sex or race or age or disability or religion? If so, it's easier to make a tied-in case. But if it's sort of general bullying, but it's only directed at people from one country or one color or so on, that's another way to make out a discrimination or harassment case. So the key question is, what is the nature of the harassment? And is it something that could be illegal under federal or local laws? I think there are many, many other answers in terms of organizing and coming together and addressing issues. But for the purpose of this, to see if conduct is illegal, we have to tie it to one of the protected categories in the statute.
Laura or Naja, do either of you want to weigh in on this question?
I think that was very helpful from Sarah. Okay,
Yeah.
go ahead.
No, I don't have anything to add.
Yeah. So the next question here, what impact does being a unionized worker have when it comes to workplace sexual harassment?
Yeah, I'm going to do that. Oh, I'm sorry for not announcing myself. That was Sunu Chandy on the last answer, and I'm also going to take this one. So unions have this incredible opportunity as they sort of stand in this place of advocacy for all of the workers, and they can really be a powerful ally in the work against sex harassment, and I'm so heartened to see so many recent efforts to do that. The collective bargaining agreement can be one vehicle to bring a grievance for sex harassment. That's not required. You can also go to HR or go to EEOC or take any of these other channels. But the union grievance process is one vehicle for addressing sex harassment. And in all my years at EEOC, I only found the union liable once, and that's when it sort of dealt with all the other issues very informally. But when people brought a racial harassment issue forward, they said, go fill out a form. And it was a very clear sort of dividing way to treat civil rights issues. But I've seen many examples of where unions have been very positive actors in this space, and I see more and more of that. I'm excited about that.
Would anyone else like to weigh in here?
No, thank you.
Okay, the next question, and this goes to all the panelists. If a client presents with both sexual harassment and wage and hour issues, can these be combined in one complaint, or do they have to be pursued separately? Must you exhaust administrative remedies for both before you can file a lawsuit?
This is Sunu. I can start, but I definitely would like the NELP folks to chime in. It can definitely be in one complaint. I would just keep your eye on the time frames and the statute of limitations, because if your charge is pending on the civil rights issue with EEOC, you may need to go ahead and file and then sort of catch up or have two separate complaints. But if you filed with EEOC and obtained a right to sue letter and you are ready to go on both claims, you could definitely bring them in one complaint.
And I don't think there aren't any exhaustion requirements for the FLSA, but I'm not sure if in your particular state, if your state wage and hour statutes or regulations may have that. I'm not sure if any of them do, so I shouldn't speak to that. Laura, do you know anything about that?
So I would also agree at the federal level, there's no exhaustion requirement. I have not encountered, I think, exhaustion requirements for minimum wage violations at the state level, but I do know that in some cases for things like retaliation, even when it's retaliation based on minimum wage compliance, there may be some administrative exhaustion requirements at the state level. So it would be good to always double check that.
Great, thank you. So this is a question for everyone, I think probably directed towards NELP folks. When would you recommend using an alias versus a real name in complaints?
Laura, you should.
Is that something you've had some experience? Oh.
I don't have.
Yeah, I think this is Laura from NELP, and I think in some cases it can be difficult to file as a John Doe or Jane Doe. I know I've tried it in certain civil rights related cases, and it can be a little challenging to get permission to file using those names or general names. It can be done. I have not tried to do it, I think, with wage and hour cases. So I think I can look into it further and get back to you offline.
Okay, great. So the next question, this is for Sunu. Does the EEOC favor group complaints, or do they prefer every complaint to be separate?
So this is more sort of behind the curtain a little bit, but if a charge is filed as a group charge and it looks like a systemic issue, then the EEOC is more likely to think about it for litigation, because EEOC brings cases in the public interest. And so that if that's something you want, I would definitely focus on the group aspect of it. You may not want that. There's also having individual complaints can be important for the time frames. So some of the individuals impacted may be outside of the window and are sort of what they call bootstrapped in. And so you risk having the people with timely claims being caught up in that mess if there's not a separate charge. So it's really a strategic question about what the goals are, what the individuals are seeking, and what the long-term plan is. If you want EEOC to consider it for litigation, I would say maybe have the best of both worlds, have 5 separate charges, but then file them together and say, I'm an attorney representing these 5 individuals, so that they're seen as a group and can sort of make each other strong, but then not be limited if they go in different directions ultimately.
So this is Sarah. I'm the moderator. We have just a few minutes left, but I think we're going to be able to squeeze in most of the questions. The next question is broad, but asks, are there relevant laws that do not cover undocumented immigrants, or are there undocumented immigrants protected by all of them just as a U.S. citizen would be? So I doubt that any of us can speak to all of the laws of the nation, but for our particular issue areas, if you could speak generally about whether undocumented individuals are generally protected by these laws.
This is Sunu, and this is something that I was just going to say, this is something I would bring up at every EEOC outreach training, that we absolutely protected all workers, regardless of documentation status. There's probably not too much time to go into this, and I actually don't know the updated issue, but there was the Hoffman Supreme Court case. So in some of our litigation, we did not ask for back pay because that was an area of debate and would raise issues of if someone is documented or undocumented, particularly when we had a class of folks who were mixed. So sometimes we waived the back pay claim because we did not want to make an issue of it. But in terms of protection by federal civil rights laws, absolutely they protect undocumented workers.
And this is Laura from NELP. I think, thank you, Sunu, for that. And it's a great question to bring up. And I meant to mention during the webinar that NELP actually has something we call our Hoffman Treatise. And it's basically a document that traces how courts have interpreted that Hoffman Plastics case, which denied back pay in the NLRB context for a worker after the worker had been fired. I think generally for the Fair Labor Standards Act, undocumented workers can recover back pay for all hours that they actually worked. But things can get more complicated, as Sunu mentioned, with the EEOC and with other areas of law like tort cases or tort damages. I think generally undocumented workers have most, if not all, protections when it comes to the merits, but when it comes to damages, things can get a little more complicated. So NELP is working on updating that Hoffman Treatise, and it should be available, I think, sometime in the early fall. So if that's something you're interested in, please feel free to reach out to me.
Great. That's such a great resource. Thank you to NELP for that. So in the interest of time, I'm going to ask the next few questions together and give the panelists a chance to answer what they deem makes the most sense. So the next few questions. First, where there is intersectional harassment, i.e. sex and race and age, must each category be severe or pervasive, or is it enough if the combination is severe or pervasive? Next question, is there some sense of the amount of time a court deems long enough to be pervasive and continuous? And last question, in EEOC cases, have you considered adding tort claims? And if so, how effective have these claims been for you? So looks like 3 EEOC questions. We'll start it off with Sunu, and others feel free to add whatever you'd like.
Yeah, for the intersectional harassment with multiple forms of harassment, I would definitely look at the totality of circumstances. That's a phrase that has come up in this context and very relevant. There's no need that you need to parse out each one, as the defendant will no doubt try to do. So I think that's a strategic question, and in every case, we try to look at the whole picture. And even background evidence, even if there are things that happened outside of the window, we would try to say this is all part of the setting. So absolutely bring them all together. The next question about the amount of time is very interesting. For pervasive, I would argue that it depends on the facts. If someone is there for a week and is harassed every day and quits, I would say that's pervasive because it happened on a regular basis. If someone's there for several years and has 4 or 5 incidents spread out over it, probably not. So I think it's very fact intensive, and it's almost a lay meaning of looking at this picture. Does it seem like the conduct there happened all the time? So. Was there one other question about tort claims? I think we are looking at, this is not something I know much about, but it is an interesting thing to think about, especially when there's no federal civil rights protections and no city or state protections. Is there an opening to bring a policy case or to use any of these other legal avenues to address the same conduct? So that is something we're thinking about, but I don't have more I can say on that right now.
All right, and we just have a couple more questions left, so I know we're basically at time, but I thought just since we have two more, so thanks for sticking with us. Two more. The first one, if the minimum wage in a local jurisdiction is higher than the federal minimum wage and the employee is not receiving the local wage, should the employee even bother to file a claim with the Department of Labor? And then the last question, and this is more about how to come together. There's an organization saying that they have a lot of problems across the board with Uber and Lyft as they advocate for drivers' rights. And this individual would like to know how they can collaborate with organizations on these worsening issues.
This is Laura. Oh, go ahead, Naja. Yeah, sorry.
Oh, no,
Go ahead.
I was gonna say, in terms of the minimum wage, if the local jurisdiction is higher, then I would recommend filing a claim with the local Department of Labor, along with because I'm a little unclear, but I'm guessing they meant like the federal Department of Labor. So I guess that would be my recommendation. If the local minimum wage if there is a local state or state Department of Labor or agency that enforces it, then I would file the claim there first. Laura, did you have a suggestion?
Oh, thanks, Naja. I think I would just add that if the worker is also owed overtime and not just the minimum wage, then they could consider filing, I think, a federal DOL claim, but I think it would be good to assess kind of more of the facts and possibilities with the case. Yeah,
and it's not to say that it's not exhaustion, but I do think, like, with issues like that, it's fine there's no like drawbacks that I can see for like, filing in both places, unless there's something I haven't thought about. Like, you can just move forward and like with your claim in both, if you're going to an enforcement agency for them. I don't think there's a drawback to filing in both places.
Yeah, this is Sunu. I mean, in terms of the civil rights laws, I can just say, as an analogy, the federal agency would never investigate or enforce the local laws because there were so many in DC. There were 19. Now I think there's more areas of protection. So you would need to go to the city or state agency itself if that's what you're trying to investigate or enforce, definitely. And I don't know if there are comparable work sharing agreements as there are on the civil rights side, but even with those work sharing agreements, the federal agency would not investigate or enforce state or local protections in the civil rights side.
And then the last question about whether either the National Women's Law Center or National Employment Law Project are working on issues that drivers for Uber or Lyft are facing.
Well, I mean, this is Sunu. I would just say, and I don't think particular to those groups, but I think the idea of workers who don't have federal civil rights protections needing them is absolutely an area that we care about, and we're doing policy advocacy on across the board. And those are, you'll see in some of our links, we'll say, here are all the groups that are currently left out. We're supporting local and state efforts to include them, and also advocating on the federal side. So absolutely in that broader context.
And yeah, same with now, we work on the issues of with the transportation companies on Uber and Lyft all the time, and focused on like advocating for workers in those companies. So definitely we can be in touch regarding those issues.
Great. So I want to thank everyone so much, particularly our presenters, for joining us today. I want to remind people that we will be sending out the slides, which include the transcript, after today. So look out in the next couple of days in your email for the slides. And I also want to make sure that you take a look at how to join our legal network for gender equity. That information is in the slides. You can also find it by Googling National Women's Law Center, Legal Network for Gender Equity. And I know both NELP and the National Women's Law Center look forward to continued cross-training of this sort so that we can build up our strength as advocates in these times that require robust understanding of all the different protections that low-wage workers are facing. So thank you so much, everyone, and have a great rest of your day.